Hi, I'm Sam Castor, the Bald Believer, here on Lex Lumina, Law and Light, and we're here today with Chris Austin, one of the most incredible trial litigators in the state of Nevada, very experienced, and we're delighted to have him here.
Thank you.
Chris Austin is an exceptional trial attorney, probably one of the most experienced trial attorneys in the state of Nevada. He'll deny that.
Yes.
But former JAG, I've known Chris a lot over the years, used him when I was an in-house attorney at Switch. And he's probably one of the most experienced intellectual property attorneys in the state of Nevada. I would also submit. I had a lot of fun stories that we've shared over the years that he's told me about his adventures. And so, Chris, we're delighted to have you here today.
Nice to be here. Good to be here.
You're a rock star. And one of the really cool things about Chris is you just turned 60 and ran a marathon.
Well,
something like that.
I've run many marathons.
You've run many.
Many. But for my 60th, I did something a little more unusual. We did a 60-mile ride.
Yeah, that's incredible.
Which I was not prepared for because it's a different skill set than what I normally do for going and running.
Yeah, I see you almost every morning. I go on a walk with my dog, little Coco, and I do like a little four laps around the park, maybe a mile, and then Chris is like coming back with Dirk Johnson, one of our neighbors, who's in the Air Force, flies helicopters, and you guys are both like these mountain men, iron sinew kind of guys, and you're coming back after doing like how often do you run every morning?
Well, minimum of three days a week, and usually about 6 to 8 miles.
Yeah, see, that's incredible to me. Very inspiring.
So.
But that's kind of the energy I always get from you, is that you're just that intense, get it done, run the marathon, win the race kind of guy.
Well, it's an interesting way to look at it. For me, it's a way to set the stage for the day. That's my way of kind of having the one win, the early win in the day that sets the stage for the rest of the day.
Yeah, I love that. Well, it says a lot about you that you're committed to that and that you have that discipline. And so it's interesting because a lot of attorneys are actually afraid to go to trial.
Yeah.
Why is that, do you think, and why do you like going to trial?
I think the adage that fear is what holds you back is true, and the reason that you have that fear is because of the same thing that's been said for many, many years. You're not prepared. The way to overcome fear is to be prepared, and the only way to be prepared for trial is to do trial, is to start going and doing it. In my case, that was by necessity. I grew up expecting to be more of I grew up wanting to be a lawyer. And the idea of being a lawyer was the guy that goes to trial and is able to stand up and win the day with the jury or with the judge.
And you've done that a lot now, yeah.
I've had that opportunity a lot, but I started off doing that as a trial lawyer for the United States Air Force. And in that context, you're really forced to go to trial. So in a very short period of time, I'm 20-something jury trials.
That's incredible.
In a matter of a few years.
Well, and today, most attorneys will maybe go to trial once in their career, maybe twice. 98% of cases settle? They do.
But as a result of that, you miss something that's hard to replicate. If I go back, and people have asked me, when's kind of the turning point? And it's several trials in. The first several trials, you're going in, they're very, you're uncomfortable, you're not sure what's going to happen. There's some unpredictability to it, right? So you go in there as much as you can, prepared with almost scripting what you're going to do. And your focus is intentionally on yourself. That's the problem as you go into a trial work. It's anything we do. If you're focused here, you're missing what's going on. You're not seeing the jury's response. You're not seeing the judge's response. And it takes, I would say, about 3 to 4 trials or more to where you start forgetting yourself in the process.
Yeah.
And you're comfortable that you're going to be able to respond to what happens because you know the case so well. You know it better than anybody, that you're able to focus in and see what the judge is doing, read the body language of the jury, and even better if you've got consultants that you can work with that can help you understand what the jury is doing.
Sure.
Then you're able to respond in the moment and you're ready to go. And once you've done that enough times, that confidence then makes it the thing you want to go do, because that is the day when your client actually gets their day in court and they get their opportunity to help the world understand what was going on in their world at that time that has brought them to this place where they've got to be in court. Now, those early trials, those were all criminal cases, and the majority of them, in my case, I was representing the defendant. And so you'd say, well, what's the great thing you want to do on behalf of the defendant? It's not common that a defendant is innocent or has not done something that is warranting a trial in a criminal context. But I found that in every one of those cases, there was something redeeming about that individual. And all my cases in the Air Force, my defendants were individuals Most of them were very young. Most of them made very dumb and, exercised poor judgment. Some were borderline malicious. I only had one that I would actually categorize as evil. But every one of them otherwise I felt had redeeming characteristics. And obviously as a defense lawyer, the mantra is I'm there defending the Constitution. I'm defending a system of justice by making sure that it's not abused and that we're following the rules. That wasn't enough for me as a defense lawyer. I was there because I felt that this individual could be redeemed.
That's beautiful.
And that this was the process that he needed to go through, or she needed to go through, to be able to get their life back together. And so my intent was to help them make that transition. And that was, of all the things I did as a JAG, that was probably that was the role I played that I enjoyed the most, was the most challenging of my life, mentally, emotionally, spiritually, and physically. As a defense lawyer, I was trying cases 200 days out of the year.
That's incredible, yeah. Well, would you, and I know you say, we use different words to describe our roles, lawyer, attorney, counselor, these different functions. It sounds like in some respects you were leaning into the counselor role, where you were you counseling these people?
Oh, absolutely.
Yeah.
Because I'm looking at oftentimes somebody who's maybe 20 years old, 19 years old, and they may have done something really dumb.
Yeah.
Criminal. I mean, obviously it's criminal. That's why they're getting charged. But in most every case, especially in the context of our military services, they were at one point a highly disciplined soldier.
Sure.
They had to go through a boot camp experience. They had to perform, and they were. Then they found themselves tempted by, like anything else that the world may tempt them by, and for whatever reason they chose poorly. They went along with the group, or they made the decision on their own. But because I know where they have been, I could come back to them and say, look, you're not likely going to be in the Air Force any further. That option is going to be removed from you, most likely. But that is not the end of your life. Do not make this the turning point that goes down. Make it the turning point that goes up.
Yeah.
And the way you do that is to take full responsibility for what we're going to have here. We've got two options. We can make sure, number one, that whatever's charged against you is the correct thing for what you did.
Sure.
That we're not, because it is the nature of all government institutions, or of all things with power, to abuse that power. And that is certainly true of our prosecutorial system, both in the civilian world and in the military justice system. And I've seen that as well, even in the civil side. It is inherent in the nature of somebody who has that power to want to push it to the furthest extent.
Power consolidated is power abused. I agree. As soon as someone has that, the likelihood of abuse
And
is high.
so the option then is to let's make sure we get justice, that everybody understands exactly what was going on here and what the true nature of this crime was. And in most cases, it's more stupidity and poor judgment than it is malice. Okay? And get that understood. Then let's come back in and talk about mitigation going forward. Yeah. And in order for that to be successful, you have to have confidence you have a future. You have to be able to understand I can go from here.
You have to have hope.
Yeah.
Yeah.
And so I looked at these guys as all being very young guys, even though they were, they're not that much younger than I was at the time. Yeah. But I felt like my role there was really to try and help these guys go forward. I had one case that was this is the greatest case for a defense lawyer, right? The greatest case ever in a defense lawyer is an outright acquittal, right? So I had one acquittal. Out of all the cases I tried and all of the plea agreements we went through, I had one that was an outright acquittal. And he was absolutely guilty on every charge that he'd been charged with. There was no question, okay? And he knew it. The acquittal came as a result of the government failing to comply with the speedy trial requirement of the federal Constitution.
That took too long, yeah.
Because in the Air Force, there is no such thing as bond. You're incarcerated until you go to trial. So once that happens, the constitutional right to a speedy trial adheres, and you have to get that guy tried. And if you don't, you're going to bust that speedy trial. Now, in the federal system, it's kind of waffly as to what that deadline is, what that cutoff is. But in the military system, we write a date in. You've got so many days from the time you incarcerate them by our rules to get them tried. Otherwise, it's presumptively a violation of speedy trial.
So what did you tell him when he got acquitted, meaning there wasn't a ruling one way or the other, he got a get out of jail free card?
I said, because I saw that they were going to incarcerate him, and I could see they had no basis for it. He wasn't a flight risk. Yeah. And the conversation was along these lines. It says, there's an opportunity that we might be able to get you 2, 3 to 1 for the time you're incarcerated. But to do that, you're going to have to show to the judge and to everybody else that in order for them to be comfortable with that you're somebody worth giving it to. So you need to be model prisoner. I mean, absolutely the best guy you can. And so I worked with him on what that meant. And that meant, number one, in pretrial confinement, which in pretrial confinement, you're innocent till proven guilty. So you're treated like a guest in the prison system. They can't make you do anything. They can't assign you duties. You're separated from everybody else. They bring you your meals. You're not a convict, right? Drives the security police and the prisoners absolutely batcrap crazy. They hate it because in their mind, you're here for a reason, right?
Yeah.
And we now have to go out of our way and be your valet instead of treating you like one of the other guys.
We're your servant instead of your guard.
So my counsel was, I said, look, the first thing you got to do is you want these guys to be on your side. Nothing works better for somebody in a mediation than having their guard come in and testify
and
on their behalf that this kid gets it. He is taking responsibility for what's happened.
Sure.
Step one is waive your right to be treated separately and asked to be put in general population.
Oh,
right.
Really?
Yeah. That's step one. Step two, sign up for the grungiest jobs that nobody else wants. So you're doing KP, you're doing the bathrooms, you're doing the lowest janitorial work, and you do it with a smile, and you do it as best you possibly can.
You basically got him to do penance while he was in jail.
And that's the point. I says this may be the only punishment if everything goes well. This may be all you end up having to do. Do it the very best you can. And that'll also help you understand that there's more that you can do than you thought you could do, right? That you have greater level. Go back and pull that discipline you had in boot camp and bring it back. Yeah. And so I viewed that opportunity with him, and there was a lot of counseling with him on that. And then there's strategy involved, right? I'm continually reminding the court, like, when are we getting this to trial? I'm continuing having him talk to his jailer. Says, I don't know why I'm still sitting here, and we watch the clock expire. And ultimately, we prevailed on my motion to dismiss the case with prejudice for failure to comply with the constitutional right to a speedy trial.
So he got out. And do you feel like it changed him?
I think he did. I think he came out a totally different person. We talked about, how he got into this position and why it was a result of him hanging out with some guys in North Vegas that weren't very good. Yeah. And wanting to kind of fit in with that group, and he's young. And as a result of that, he and his buddy went and kited checks from his buddy's grandmother's card, bank account, including a down payment on a Cadillac. And why you've got a 20-year-old wanting to buy a Cadillac is beyond me, but that's what they went and did.
Yeah, unwise decisions in the age of youth.
And then there were just the numbers of those, they went down the rabbit hole after that. But
that's terrible.
None of them they were mostly financial crimes.
Yeah.
So in the end, I feel like that was one of those guys that to me was a great success on every level. It was a success on the legal side. I felt like I represented him correctly and held the system to account, but it didn't result in a guilty person getting off, in my opinion. He was effectively redeemed and punished at the same time. He paid a price, and that price was to modify and change his behavior and his attitude going forward.
That's pretty remarkable.
So for me, that's why I look at that case as one of my favorite ones. Now there are others that are on that line, but that was my favorite one.
I'm so glad you told me that story, because you were acting as a counselor. You were helping this young man change his life, find a path of redemption. I mean, that's beautiful.
Well, and that's really what we do as lawyers anyway. I mean, I'm now in a very different context right now, functioning as an IP lawyer.
Yeah. And intellectual property is very different than criminal prosecution.
Very different,
right?
but people are people.
Yeah.
And at the end of the day, what you find is, even though I may be representing Briggs & Stratton, which is this giant corporation, right? And I'm representing them in an emergency injunction to try and seize a knockoff lawnmower at the National Hardware Show in Las Vegas, okay? I'm still dealing with that one executive for whom it's personal, right? And who feels like it's just unjust that we have spent all this time and energy to develop the engineering, and in this case, to put together a iconic design, which is what we call trade dress, the design on the shroud of the lawnmower. Right?
Sure.
Something very basic, but it gives it that cool gee whiz look. It has nothing to do with the functionality of the lawnmower, but it is something that sets that particular product aside, and that bright red and that diamond and bar logo. Yeah. That means something. Sure. To the executives and the designers and the engineering team and the marketers who put blood, sweat, and tears into putting that together to create the market for their clients, and it is personal to them.
Yeah.
Even, you wouldn't think it would be, but it is. Now, you've been in a big company, so you understand that
Sure.
as well. And it's definitely personal
100%.
to the founder,
100%.
who you had the opportunity to deal with.
Yeah, and he was incredible. I mean, a genius and always doing amazing things. Rob Roy, the founder of Switch, and the president, Thomas Morton, both incredible humans. And you do have to understand how to reach in and say, hey, I want to support you in this role. I want to help you, move the mountain you want to move, or build the bridge you want to build. So, but you mentioned something interesting about seizure, and I don't think a lot of people know this, and I didn't know this about you when I first met you, but it's probably one of the coolest things you do. So you've done intellectual property seizures where you do an ex parte order with the court, which means you go in and file the motion without the other side being able to respond, and you say, they're copying our stuff, and we should be able to seize it and fix it.
That's exactly what it is. So, I mean, another case I had was on behalf of Antique Jeans.
Okay.
And at the Magic Show, which is the apparel show that's done in Las Vegas every year, they identified another jean that was knocking off their unique stitching design on the back of their pocket of one of their jeans.
Sure.
Okay. And that is protected by federal copyright law. Well,
stitching design is
stitching design can be protected by federal copyright law.
Yeah. Okay.
And as a result, they're looking to try and, we got to get this done. The problem is, they're going to identify that on the first day they get to the show. That's when their own crew people and others that are working with them are going to say, wait, that looks really a lot like our gene.
Yeah.
Right, or at least our design.
They're copying us.
They're copying us.
Yeah.
Can we do something about that?
Yeah.
And you can. And what you do is you then contact me or somebody that can do what I do, and we developed this practice pretty robustly back at that time. And we're developing that again now.
Yes.
You've got to file a complaint. You've got to have a motion that's attached to that complaint. All of that has to be done ex parte because most likely the defendant isn't here. And so if you do it with notice and they receive notice, they can pack up and leave, and then you can't serve them to commence a lawsuit. And that's particularly the case if they're a foreign potential defendant.
Entity, yeah.
Which in many cases they were. They're often Chinese defendants that are knocking off American products.
They're here in town for a show.
You're in town for a show. And it's critical for the American companies because these shows are often the show where the annual contracts for distribution are signed.
Sure.
Or they're at least well negotiated.
Huge financial impact.
Huge financial impact. So I know, for example, another client that we had was Bond, which is the OEM for Black & Decker for their outdoor tools and goods. They're also the OEM for Lowe's and for Home Depot.
What's OEM mean for people who don't know?
So the original equipment manufacturer. So they're at the actual, when you're buying something that may say a brand on it, that doesn't mean it's manufactured by a factory that has that brand's name on it. It's probably manufactured by somebody else.
And then they white label it.
And then they will label it. They may make that same product in multiple different variations, color schemes. It's going to be orange if it's going to Home Depot. It's going to be blue if it's going to go to
Lowe's,
Lowe's, that kind of thing.
I see this with cars a little bit too. I look at cars and I'm like, that's the same body underneath.
It can be.
Yeah.
And so in the end, their concern is they're going to go get a contract with Home Depot for their knockoff version of our product, or they're going to get a contract with Macy's for their knockoff version of or they're going to get a contract with Target or whatever, Walmart.
And the reason
for their knockoff of our antique jean, right? So
yeah.
that's their concern, and it's going to be an annual contract. That's worth hundreds of millions of dollars potentially. And we've got to stop that from happening. We don't know who they're talking to at this show. They all can go off into private places and have these conversations. We need to get an injunction from a judge that bars them from selling this product in the United States and that seizes any product that they currently are showing and shuts their booth down, right? That's what we need to have happen. We have 72 hours to get that done because most shows are about 3 days.
Yeah.
Right. So that requires a well-oiled machine in order to get that to get that happening. Because in that context, like I said, you've got to have a complaint. That's a sizable document to put together. You have to have a motion, which is, for a layperson, think a term paper, highly cited,
technical, complicated,
very, very detailed in why you get everything. It's the argument in writing for why you should have this happen. You've got to then get in front of the judge, and all that has to be done ex parte, which means you have to explain to the judge why we're going to not give them notice.
We're not going to tell them about it. Yeah.
Even though our laws normally require notice, we're going to say this time we get the exception. They don't get notice because if they get notice, we will never get any relief. We'll give them notice after they show up at the first hearing.
Sure.
Okay. And we're asking for both a temporary restraining order and a seizure order and a preliminary injunction. So the temporary restraining order has a 2-week timeline limitation on it normally.
So you gotta go fast.
You only get it lasts only a short period of time.
Sure.
And then you come in and you have a full preliminary injunction that will last until there's a final judgment and the case has gone to trial, right? That's the idea.
So you go get an order from the judge that says, yes, you can go in with a U.S. Marshal and take
the item.
Yeah.
So to do that, I've got to coordinate with the judge to get a hearing in front of the judge solo, right?
Okay.
Because there's no opposing party's been notified. I've got to also, if I'm dealing with a foreign defendant, I've got to coordinate that with the United States Attorney's Office so I don't run by statute, I have to clear it with them because they may be doing a separate investigation and I may be screwing it up.
Sure.
If they don't know what I'm doing. I've got to clear it in this state. I've got to clear it with the venue.
Yeah.
They're not going to let me in. They don't particularly like it when we come in and do these things, so they may want us to do it after hours or whatever because they don't want to disrupt their show. And I've got to coordinate with labor because all of these shows are contracted through labor. So Freeman is going to be probably involved as well. So there's a lot of moving pieces. And then I've got to also somehow get the marshals to do it. And this is a post-duty opportunity for them. It's like an
on the side.
An on the side, something they can sign up for. Some of them really enjoyed it. I had one marshal that always wanted to sign up. He loved these activities.
It sounds fun.
Already would have come down to do it. He had a blast with us. So,
you bust into the show and you're like, hey, we're taking all your teddy bears.
Taking it all. Right? So so then when that all comes together and you finally get the order signed, then you've got to coordinate everybody's arrival, get there, serve everything, remove all the people who could cause potential problem if they get upset. It's more like a criminal bust in that context than a civil action. And then you just start wheeling it out. Right?
So maybe intellectual property isn't that different than criminal law.
At that level, it looks a lot like it from the prosecution side. I mean, one of my funnest experiences on this one was we on behalf of Briggs and Stratton, we got that seizure order to remove that knockoff of a lawnmower, right? And one of our arguments was that it was tarnishing the brand because it wasn't the quality of a Briggs and Stratton lawnmower, right?
Yeah.
And so that then diminishes Briggs and Stratton's reputation. And in the context of trademarks and copyrights, particularly trademarks, that is the goodwill. That mark.
That's the value.
Is the value. That's a $100 billion mark, you know. So we're wheeling the lawnmowers out, and literally the wheel off of the counterfeit lawnmower fell off the machine as we're wheeling it out, as if to just prove for sure that we had the right theory of tarnishment on that.
This is the fake stuff right here, people.
Just so
watch
you know.
this break. That's really cool. Okay, so let's talk about trademarks for a second.
Yeah.
So in my experience, I'm sure I haven't done this as much as you, but when I was at Switch, we would go around and we would actually get other people to stop using the name Switch for their brands and purposes. And I think I probably did it, I don't know, 15 times. We were on a let's go prove that we're famous path, right? We're trying to prove to the world that we're distinct and famous. And it was a lot of fun. You've done that too. And we have a case right now where we're trying to stop someone. And we won't get into that, obviously. But do you want to talk about that process a little bit, like what it's like to enforce a trademark? You've done a lot of trademark stuff.
Trademark stuff and patent stuff, yeah. Trademark is probably more ubiquitous because it's all
everywhere.
Everywhere.
Yeah.
And it's like we were talking about, because it's the embodiment of the goodwill of the product and the mark, you've got to really work hard to try and, number one,
protect it,
keep other people from infringing or what I would say diluting it. So what you're talking about with regard to Switch, you're trying to prevent dilution. So you can have a clear pathway to say we're exclusively, when somebody hears Switch, there's an instantaneous understanding of what that means. And by removing dilution is a harder path to go, because typically trademarks are limited by the good or the service that's offered under that mark, right? So in the case of Switch, you're offering data center services, right? All the services associated with operating a data center. But somebody else might be using that word Switch they could use it for a computer, or they could use it for a repair service associated with your server.
Getting a new cell phone that's whatever.
You could use it for a lot of different things that technically aren't infringing of your mark, right? But by definition, narrow where your mark can be expanded to.
Sure.
Because now you're going to run up against somebody who's using it here and there, and so you're locked into a narrower position. A famous mark has almost no barriers. Because it's not possible for the person who hears that mark not to immediately recognize the company that it comes from. Because the whole point of a mark is to identify the source of that good or service. It's not just, gee whiz, that's a cool mark and it identifies this little product or something. It could, but what it's really identifying is, you know what, this product comes from, you know, in my case, it's shoes. I have a particular favorite brand for running.
With all the running, yeah.
And so I have become a very much a fan of what's called the last four. Every shoe company has different last. So the last that I like the best is the one from Saucony. It best matches my foot, right? So I don't think I could hear the word Saucony and not instantly think of the shoe company Saucony. I'm not going to think of a particular shoe. They all have a different name.
Sure.
But the reality
association's
is associations. Now,
Yeah.
Similarly, if somebody were to say Nike, I don't think it's possible for somebody to put Nike on anything and not have somebody immediately think of the Nike apparel and running.
Yeah, it's a famous mark. Yeah,
it's a famous mark. And so you're doing that with Switch by trying to remove all of the various things that could dilute the value of that mark, so that when people hear Switch, they're thinking that the company that runs the data centers. And even if it shows up on some other thing like a phone or whatever, like, yeah, are you affiliated with? You're going to raise that question. And if you can cause people's minds to raise that question, you've got a famous mark.
Yeah, that's great. That's great. So how valuable is intellectual property to a business?
It's essential. It's the critical thing for the company, in my opinion.
Why is that?
It's what distinguishes you from the rest of competitors in that market, and it is also the thing that makes you a known entity to the population. As human beings, we don't remember particularly all the bells and whistles of a particular product. At the end of the day, we associate a product with a brand that we like.
Yeah.
And then once we have that, then we begin to think that anything I get from that company going forward, even if I've never tried that product before, is also going to be of value to me. That is the goodwill. That is the trust in a company that's built because of the brand. So nobody has to think now, oh, if I go buy a Honda, is it going to be a decent car? I don't know. It's a new Honda. I haven't heard any reviews on the new one yet. No, I'm pretty confident if I buy a Honda or a Toyota, those cars are going to be solid.
Quality.
They're going to be quality cars.
Yeah.
They've got a reputation, even though, so I don't have to worry about whether the newest model that comes out is going to be a good car after I've got to go test drive it, go find the reports on it. The brand alone tells me it's a good car. And that is incredibly valuable in maintaining your market share, being able to build and add to that market share, and even to expand into other areas and other markets with that brand. There's no other way to replicate it.
No, I agree. In fact, and I think it's true across all goods and services. I had a friend who we interviewed earlier, Tashelle Lawson, and we talked about how she was writing a book. And I was like, if you're writing a book, you need to pick a name. What's the name? And she stewed on it for a while, but as soon as you get that name dialed in, it's like, all of a sudden, the energy and the value in the brand starts to coalesce, right?
Yeah.
And forcing people to change that, or being forced to change that, it just sucks. It's like you just had a baby, an idea baby, and all of a sudden you're being told you can't use that name because so-and-so is using it. It's just devastating, right?
Yeah.
So how do you make sure a business avoids that? What do you do to help them along that path?
Yeah. So I'm going to deal with this in two ways.
Okay.
Because inherently businesses, especially new businesses, don't understand what the point of a mark is. Oftentimes, what they think they're selling is their good or their service, and they want people to know what their good or service is. So that's what they're trying to brand. So I had many, particularly doctors, I don't know what it is, but they want to come in and say, I want the brand for being Doc Vegas, because I'm like the best doctor in Vegas.
Okay. Okay.
And I've got to come back and go, that's not a brand. That's a description.
Yeah.
And I cannot protect it.
Yeah.
Because the whole point of a trademark is that it identifies a unique single source of good and service. You cannot take out of the English dictionary or any language words and bar everybody else from using them for their actual meaning.
Right.
Right? That's not a trademark. That's a description of what you're doing.
Water. I sell water. No one else can call this water.
Right.
Yeah.
So if you go back, you remember there was I think it was MGM that had the hotel.
Yeah.
Do you remember? Right. So for a brief period, all the trademark lawyers in town, when we saw them label that hotel, the hotel, it's next to the Four Seasons, right?
Like,
Next to the Four
this
Seasons.
is not going to work.
Like, that is the most ridiculous name possible because you cannot protect it. You will not be able to get any protection from it. Now, arguably, maybe over time, you might be able to come in and say, well, everybody's just going to know that the hotel is is the hotel associated with whatever MGM.
After 5 to 10 years, yeah.
You know, I said, but the reality is maybe, but the actual reality is no, because in that context, it's literally generic for what it is.
Yeah, it won't work.
It is a hotel, and you put the word on it, as though that makes all the difference. It doesn't. It's going to be a hotel for a hotel.
Yeah.
So that's the first step. It's helping the person who's got a new business understand you need something that actually does not describe what you do. That's a hard sell. You need to be able to identify your product in a way and identify your company in a way that doesn't immediately tell somebody what you're doing, which is the last thing a new business wants to do, right? You've got to have some, so the next level, then that's where good level, marketing people come into town.
Strategy,
because you got to come in and go, okay, you can have a mark that suggests it. There's got to be at least a leap in the mind between what you say and what you're doing. So if I'm
quarter turn,
right. So if I want to be a tribute band to the Beatles, I could name my band Penny Road, right? But if I name my band Beatle Tribute Band, I get no benefit for that.
Right.
But if I name it Penny Road, I'm not the Beatles.
Or Hard Knock Life
But
or something.
anybody who's interested in the Beatles is going to know immediately.
Yeah.
There's going to be a little leap. They're going to go, oh, Penny Road, that was a Beatles song. Oh, you must be a Beatle tribute band.
There you go.
And there's an ability to gain some reputation on that. But that's really I say get some good marketing people that kind of brainstorm about what your industry is about, how customers are viewing it, how they feel about it when they look at it. What is it that they're trying to go after that you can appeal to?
Sure.
That's one way to do it. Or you can do like the pharmaceutical companies. And I've found nobody better at creating arbitrary words out of English letters than pharmaceutical companies.
Yeah, just
because they've mastered Latin, right? They know all these terms. And so they manufacture brand new words.
Yeah.
I mean, the word Viagra is not a word, right? It doesn't exist. But everybody now, when you first hear it, you almost immediately get a sense of what the word's about because we're taking roots.
Yeah.
That have the idea of vitality, right? And that have the idea of growth and ability, right? There's all built into that. A very creative marketing person created a single word that was really easy to glom onto, that after a little bit of thought, with a description of what the good was, makes perfect sense.
Well, and there's a lot of bad examples too. Like I've seen, because I did a lot of Silicon Valley stuff when different startups that we were helping in my former life at Switch, and people would come up with names that you go, everyone's going to ask, how do you spell that?
Yeah.
Everyone's going to wonder, what does that really mean, right? And so you got to walk that fine line, right? You got to find something that resonates, but also something that's not confusing.
Yeah.
Yeah.
Yeah. So those are your challenges. I'm looking at companies that are coming in, or a new individual wants to do a startup company, and that's the conversation you're having with them about marks. Let's find something that I understand that tension that you're trying to work with. Good marketing people can help you bridge that. I can help tell you whether or not it's going to fly, and I can get it registered, and I can get you protection.
Sure.
Because I'm going to be looking at whether or not it describes your good and service. And the more it describes your good and service, the narrower you're going to be. If I'm able to get it past it all, the narrower your lane's going to be, and the cap on where you can expand is going to be. Yeah. So the broader, the less descriptive, ironically, of what that brand is, of what you're doing, the more potential you have as a brand. Going forward, right? Yeah. We all now use the word Google as a verb to identify the source of what that good was. That was never what the word ever meant.
No, for sure. And same with Xerox, right? In fact, Xerox ran a campaign. Oh, no, Velcro. It was Velcro. Did you see the Velcro video?
Yeah.
They ran a whole campaign about how this isn't Velcro. That's the name of our company. Yeah. Because they wanted to make sure they protected their mark.
Well, there are a lot of. Kleenex for a while almost lost their brand. Aspirin has no longer a trademark. It used to be a trademark for Bayer. No, now it's an ingredient.
It became so ubiquitous that it lost.
Now it's gone into the public domain as an ingredient. Yeah. Aspirin isn't an ingredient. It was a contrived word. It was manufactured, created.
Yeah, like Viagra.
Whatever. It was just something came up that some brilliant minds came up with, but it became so. Bayer stopped. Bayer itself started calling it as an ingredient in its other medications. So we give you, so Excedrin has Excedrin now has an ingredient. Aspirin as an ingredient instead of whatever it's called, acetyl something or another.
Yeah, acetaminophen. No, that's Tylenol.
There's something else.
Yeah.
It's acetyl something. It's a silly. It's an acid at the end of the day, but I can't remember what it is.
Okay, I got 3 more questions for you, and these are questions that I ask every guest. And because we're talking about law and light, we spent a lot, and I love the counselor discussion at the beginning, but let's talk about what you believe, what your why is, and what do you do in your daily life to create light. So which one do you want to start with first?
Well, what do I believe? Well, that is at a very fundamental level, I believe that we are all eternal beings and that we are literally the offspring of God and that our potential is unlimited and is far greater than we know.
Yeah.
I am a very passionate and religious man. That is core to who I am. And I view, my view is that everybody on this earth is of value. Even those who have lost their way, there is value and there is something there to be redeemed. And I hope for that for myself as well. So that's core to the belief. My why. I'm fundamentally a problem-solving person.
You are.
That's my, I don't know how you be a lawyer if that's not what you do.
Yeah.
And there are days in which I get tired of feeling like I got to solve everybody else's problems.
Yeah.
But I also enjoy the creativity that comes from trying to do that.
Yeah.
The practice of law is fundamentally a creative one, in my mind.
Sure.
It's a process of using the tools that we have, but we're not limited to those. There are other things we can do, and I think we do well to get involved in counseling, well to advise, to talk to other experts, like we're talking about in marketing, or whoever, to help solve or prevent problems going forward. Most often in our situations, especially if you're in my case, if you're in litigation, you're coming in because there is already a problem that needs to be solved.
Sure.
Something didn't go right, and we need somebody to come in and try and figure out a way to fix it. And
Quickly and low cost.
quickly and as efficiently as you can.
Yeah.
And that can be very tough, especially if in a litigation context, if that's the solution we need to go down, it's going to be a costly process. There's no easy, cheap way to do that. That our system, our adversarial system, as best as we can contrive it, is still a very inefficient and expensive process.
So creative problem solving is valuable in that scenario, especially.
Yeah, because there are things you can do. I mean, there are strategies you can take to try and mitigate against what you know will likely come up if you can get the other side to agree to them, that will limit the expenses you may run into in a litigation context, that may trim the kind of motion work you're going to have to engage in, or that might more quickly get you to a resolution.
And I've seen you do that. In fact, we've in cases we've actually gotten the opposing counsel. This is your idea, to agree to not do certain motions, like motions for summary judgment. Let's just go ahead and get to trial as quickly as possible. That's a very valuable thing for a client, right?
Well, in that case, it made sense because we were looking at two bet the company marks.
Yeah.
And so the idea that this would be resolved without going to trial was unlikely. You're fundamentally looking at issues of fact that we could look at and go, this is, number one, we're
going to fight to the death.
We already know judges are not likely to grant motion for summary judgment if they can identify there's some kind of an issue of fact. And I'm looking at it going, there's going to be a lot of things we could quibble on, but at the end of the day, we're likely going to be in trial on something anyway. It would save our client a tremendous amount of time because those motions, as you may know, and I don't know if everybody knows, but you're 4 to 6 months to get a ruling on some of these motions.
And they cost $100,000 to $200,000.
They're a very expensive process, right? Yeah. And even better, I've been involved in another case with when you've got a trusted colleague on the other side, and both of you are working to the same end. You've got a legitimate dispute. I've had 2 cases where, in one case, we couldn't resolve the dispute, but we did manage to get our clients to say, look, let's go to binding arbitration. That's hard to do. And to avoid formal discovery, let's just tell me what it is your case is about. I'll tell you what mine is. Let's go back and forth. And we had this very free-flowing back and forth disclosing the evidence to each other so we could look at it, talk about what we think are the problems with yours. And it was a very open conversation. I've rarely had that because it takes a very knowledgeable opposing counsel who's also
willing to collaborate.
Has a great trust for you, and we're looking and is recognizing, there's something here. It's not like you're bringing too often I think lawyers come back and say, well, the other side just has no basis at all. Well, no, we wouldn't be in the process of having a major dispute if there was no basis, if the other side didn't have some basis for what they're bringing. So there has to be some humility in that process. And if you can get 2 quality lawyers who understand the law and are comfortable enough with each other, trusting enough with each other, you can get quite a ways down the road. So in that case, we weren't able to resolve it between ourselves. There were still issues where we fundamentally disputed how that was going to come across. But we were able to agree that a mediation would be great, and we both had the same mediator in mind that we thought would be effective for this case.
And so you agreed on a process.
We agreed on a process that would, and a lot of it was allowing our clients to have, in a sense, their day in court, to be able to say, hey, look, I've explained this to somebody who is a third party, and I want to get their opinion on it. And that was very successful, and we were able to actually resolve that case in mediation.
That's great.
Which was it was a creative result. And the reason I like that mediator is because he's willing to think out of the box to come up with a creative result.
Oh, the best kind, yeah.
That doesn't get you whatever you want, but it does give you a pathway in the future to get what you want.
Yeah,
right. And I think that's a great way to go about it.
So let's end with what do you do in your day-to-day to create light?
Well, we started with exercise, right?
Yeah.
I don't necessarily view it as exercise per se. I'm always kind of training, is the way I look at it. So it's just another aspect, but it's an opportunity for me to keep my mind cleared. It's a form of mediation or meditation. I run with a great guy who is mostly quiet when we run. I'm the one that's mostly talking, and this conversation will range, from anything that's happening in the immediate issues of whatever it's politics or religion or whatever, to very abstract discussions, and then when we start hitting the hills, we're just quiet.
Huffing and puffing up the hill, yeah.
And that's when I find that's when I get clarity in what I'm going to do for the day.
Yeah.
I look forward to that run up. It's running up Sahara, if you know what I'm talking about. So when we're running up from we got about a 2-mile run straight up Sahara at one point in the run. And that is kind of one of my favorite parts of the run, ironically, because that's, we've talked now for about 3 or 4 miles, and now we're going to run up this hill.
Focus. Yeah.
And I'm just letting my brain just wander and allow me to just enjoy the day. I may resonate on things that I've got to work about, where things might just pop up that I'm thinking about with regard to a case or a client. And oftentimes it's in those moments that I'll get clarity as to what needs to be done, where we should take that case. Where you can't do that in the middle of trying to work through the problem and all of the evidence and all of the witnesses that you've got to deal with. It's when you just kind of let it just go that I get that clarity. But it's also the clarity I get for the rest of my life, because first and foremost, I'm a husband and I'm a father.
Sure.
And I have now 5 adult children. And I'm discovering that it's almost more work, mental energy, to help them and to counsel them appropriately, when it now has to be by persuasion only. Right?
Yeah,
I have to actually have good ideas. And I need to make sure they understand I'm listening to what they have to say.
Sure.
In order to assist them. And I have to open to the fact that I don't know everything that they're going through. The world has changed
quite a bit
in 30 years, you know. So I need to be open to what they're saying, and fundamentally their advocate, somebody they know they can come to, who cares about them no matter what, who loves them regardless. Yeah. So that's the moments when my brain is able to go to start thinking about each one of those kids. That's kind of the why, I guess, and in my own family relationships, because at the end of the day, that is the most important and the most critical reason why I do anything.
Yeah, that's why it has eternal significance.
Yeah,
I love that. Well, you are an incredible example. You've always been I've always viewed you as a mentor, a dear friend, and I'm really grateful for the chance to work with you here at Lex Technica. And let's go kick some butt on some
Absolutely. I'm enjoying it. It's great. It's a great environment to be a part of.
You enjoy it? I'm glad. I'm glad. Thanks, Chris.
You
I know you got to run.
I do.
Literally.
Appreciate it.
Thanks, brother.